I'm going to pass the matter. Mr. Allen, you can place him in back. I will decide on what his bond is and everything else. You need to go with my bailiff, sir.
Man, you sitting there. I'm
You
finna
need
do
to
a truck.
go with
Okay.
them. Call security down.
Buckle up, folks, because what you're about to witness is a courtroom moment that starts confusing and spirals into pure chaos. Today, we've got the case of the people versus Stephen Javon, or is it? From the very first words, we're thrown into an identity dispute, medical claims, conspiracy allegations, and even an art fair reference that leaves everyone in the room scratching their heads. The defendant insists he's been misidentified, mistreated, and even targeted, while the prosecution sees enough here to raise serious questions about his mental competency. But here's the twist: this isn't just about courtroom order, it's about whether the system can make someone participate in a competency evaluation when they're adamantly refusing. Watch closely as the tension builds, because between the defendant's emotional outbursts, the judge's warnings, and a bond decision that takes a sharp turn, this hearing delivers one unpredictable hit after another. Let's dive in.
Let's call the case of the people versus Stephen Javon.
Hannah Mackey on behalf of Mr. Javon, who's approaching.
The DA had my social security backwards and everything. Had me at the wrong birthday. I was born on Christmas, 12/25/66.
APA Richmond, that's for the people.
Your Honor, we're requesting to adjourn this
Can you
matter.
state your name for the record, sir?
Red Kraken. I haven't had any income or nothing. They shut down. I didn't put my name at this. I didn't put my
Hang
birthday.
on a second, sir. Have you ever gone by the name of Stephen Javon?
Yeah, they had me listed at that name. That's my.
They have that listed as your name, but you're saying your name is something different now?
They had me listed at that name. I didn't know. I woke up from what they were doing to me. I had attempts to kill me, man. I hadn't had a night's sleep or nothing. Right now, my health is down, man. I'm suffering from a gunshot wound from segregation, in which I'm
Okay,
still going
no,
through
no.
stuff. I left a hospital with open wounds. Something
Okay.
that happened
Okay, but I just
not
need
too
to
long
know.
ago. And then you were part of something. I'm really excited conflict of interest with this. I'm really just excited to kill this case, man. Because this case is, they got me the last day of the art fair. The last day of the art fair, I'm asking you to kill the case.
What art fair?
That's what happened to me. They made a false report. They got me.
Okay, all
going
right.
through this stuff, crazy
Hold on,
stuff.
hold on. At some point, I myself or some other judge will hear all of your complaints. I just need to know, do I have the person in front of me that this complaint pertains to? So that's why I'm asking you. You've been known by the name Stephen Javon before at some point, correct?
Right here, we see a classic legal disconnect. The defendant wants the judge to simply kill the case based on what he sees as wrongful accusations, but that's not how the process works. Judges can't just throw out charges mid-hearing without legal grounds. The art fair mention? That's his way of placing the event in context, but legally, the prosecution is still entitled to proceed unless a motion to dismiss is granted. Notice how the judge tries to cut through the narrative to confirm identity. That's step one before anything else can happen in court. If the court can't even confirm they have the right person, nothing else moves forward.
Yeah.
Okay,
Boy,
all right. Counsel, what do you want to do on this?
Approach, please.
No.
May we
can't keep
approach?
going because I ain't had no income. I can't keep going that stuff with it. Just doing stuff. I mean, I've had two.
Is this gonna be
cases
important?
this year.
It's okay. Yeah, come on.
This is an open and shut state. I shouldn't be.
All right. Go ahead. Okay, what are we, record to reflect, you had a brief bench conference in this case. What are we doing with this man?
Your Honor, the people would like to request that there is an order for a competency evaluation. That is on a people's motion. I think that given what we've just heard from the defendant, it's an appropriate request at this time.
Any statement?
Evaluation,
Any-
and they almost killed me. Man,
Sir,
better get me out this
Sir,
room, man. They
sir,
almost killed me, man.
sir,
I can't
sir.
keep going through this, man.
sir.
I'm not gonna go
Sir.
through no evaluation because I got an education, man. I'm not going through that no more.
Sir.
You did this last time to me, man. It's already a conflict of interest. Yeah. I'm just saying.
I'm gonna say,
He
sir,
got-
I'm gonna say,
something now.
sir, one
I
more
had a
time.
Reaction to that.
Sir.
Almost was dead from that allergic reaction, man. You and Collins, man. Already a conflict of interest.
I'm gonna order a competency evaluation,
I'm
forensic
gonna order you
evaluation.
for a competency evaluation, man.
Here's the turning point. The prosecution is requesting a competency evaluation, which in legal terms means the court wants to determine if the defendant understands the proceedings and can assist in his own defense. The defendant, however, sees this as an attack, citing past allergic reactions and even accusing the court of wrongdoing. This is where legal reality clashes with personal perception. A competency evaluation doesn't automatically mean someone is guilty or unstable, it's a safeguard. But refusing it outright? That can backfire hard, because it signals to the court there may be even more reason to question competency.
I'm finna sue y'all, man.
You wanna know
I leave
what?
here.
You keep talking, we're gonna have a problem.
I'm
'Cause
not
I'm gonna
getting no
get- I'm gonna
evaluation from
get
you.
through-
You're not gonna do
I'm
this to
gonna
me
get
again.
through this hearing.
Yeah.
All right?
Not
If
gonna-
you don't want to conduct yourself appropriately, then we'll sit you in back until you can come out and conduct yourself appropriately.
I ain't going to no competency evaluation. I don't need no competency. I had medication I shouldn't even have in me. I almost
I'm gonna
died,
let you
man.
go
I'm not
on
gonna
and try
be
to
in
get
no-
it
I'm
all
not gonna
out.
be under no pressure with no medication. I'm not gonna be taking something that I'm not.
All right, I'll
No.
tell you what I'm gonna do. I've given you 2 warnings. I'm gonna pass the matter. Mr. Allen, you can place him in back. I will decide on what his bond is and everything else. You need to go with my bailiff, sir.
Man, you sitting there, I'm finna
You
get
need
you
to
in trouble.
go with
Okay.
him. Call
I'm a-
security, call security down.
Courtroom the same way, but- Man, you, that's what the same way you a part of something that did something to me, man. all the time.
You guys might want to go check back there. That, I don't know what's gonna happen. Okay.
That's his backpack.
What? What about his backpack?
Oh, it's your backpack? Oh, I was like,
You can take it home with you. I'm not, well, they'll get it.
yeah.
Just leave it there. I am not worried about that backpack.
Should be.
I'll pass this matter and we'll come back to it,
Thank you.
maybe.
And there it is, the consequence of that courtroom conduct. The judge bumps bond up to $10,000 cash surety, which means no release unless that full amount is posted. Why? 2 reasons. 1, the defendant's behavior was disruptive and defiant, and 2, his refusal to participate in the court-ordered forensic evaluation raises major concerns about compliance. In the legal world, bond isn't just about money, it's about trust. If the court thinks you won't follow orders, your bond conditions can tighten instantly. This is a textbook example of how quickly a hearing can shift from discussion to detention.
Court calls the case, People versus Stephen Javon.
APA Rachel Duffy for the people.
And Laura Yagi, Assistant Public Defender, standing in on behalf of Mr. Javon.
All right, he is not, I'm not bringing him back out. It was a rather irritating thing. I'm sure he's aware of what we're doing, and then counsel can inform him of that. What I'm gonna do are a couple of things. I'm gonna order the forensic evaluation. I'll set a competency hearing for October 23rd, 2025, 9 a.m. I am also going to, because of the defendant's behavior, I'm going to change his bond in this case. I'm going to set his bond at a $10,000 cash surety bond in this case. I will, since he is not here at this moment, counsel, you can note that I'm setting that. He'll be held. But if you believe that there would be reasons to review that bond and reinstate his personal recognizance, then you can bring that up by motion. All right. And I'm also doing that because when ordering the forensic, he had indicated that he wasn't going to participate in that. So that's caused the court some concern. All right.
So, what just happened here? In under 10 minutes, a hearing meant to confirm identity and set next steps turned into a full-blown competency showdown. The prosecution got their evaluation order, the judge locked in a $10,000 cash surety bond, and the defendant was removed from the courtroom after multiple warnings. This case now heads toward an October competency hearing, but whether the defendant cooperates remains a big question mark. What do you think? Was the judge right to order the evaluation and raise the bond, or was this an overreach? Drop your thoughts in the comments, and if you found this breakdown eye-opening, make sure to hit like, share this video with your friends, and subscribe for more jaw-dropping courtroom moments.